Everyone, please stand. Okay, you may be seated. At this time, ladies and gentlemen, I will read to you the court's charge. Members of the jury, the defendant Omar Young Sr. stands charged with the offense of resisting arrest, alleged to have been committed in Jefferson County, Texas, on or about the 9th day of February 2025. To this charge, the defendant has entered a plea of not guilty. A person commits the offense if he intentionally prevents or obstructs a person he knows to be a peace officer from effecting an arrest of the actor by using force against the peace officer. It is no defense that the arrest was unlawful. So that you may better understand the nature of the offense with which the defendant is charged, I now define certain terms and words. A person acts intentionally or with intent with respect to the nature of his conduct when it is the conscious objective or desire to cause the result. Therefore, if you believe from the evidence beyond a reasonable doubt that the defendant Omar Young Sr. in Jefferson County, Texas, on or about the 9th day of February 2025, did then and there intentionally obstruct or prevent Joy McElmore, a person the defendant knew to be a peace officer, from effecting the arrest of the defendant by using force against said peace officer, to wit, by struggling with the arresting officer, you will find the defendant guilty, unless you find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each of the offense is proved, each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, You must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced in the evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror nor consider it yourself in arriving at a verdict. Our law provides that a defendant may testify on their own behalf if he elects to do so. This, however, is a privilege accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against the defendant. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. The last page is the verdict that's attached to the charge. It has two parts, top or bottom. The top part says, we, the jury, find the defendant not guilty as charged in the information with resisting arrest. If that is your verdict, then your foreperson will sign their name on the top line. Or the bottom portion states, we, the jury, find the defendant guilty as charged in the information with resisting arrest. If that is your verdict, then you will sign your name, or the foreperson will sign their name on the bottom line where it says foreperson. Does everyone understand? Okay. Okay. Okay, now at this time, we will have closing arguments. Each side will have 20 minutes. The state has the right to open and close the summation of the argument. State,
State leaves this right open and reserves this right to close.
okay? And so, Mr. Wilkerson, you can go first, and I'll be keeping time.
Thank you, Your Honor.
You are,
May it please the court.
yes.
Members of the jury. If I don't drop something once a day, it's not a day in court. I'm not gonna take up a lot of your time. I don't think I need to. I do want to start, and this is the last opportunity I'll get to have to address you unless after your release, after everything happens, you stay and we get to talk to you. So thank you again. I've repeated several times and I mean it. Justice is a process, it's not an end result, right? In this case, you got a defendant charged with resisting arrest. You got an officer testifying that he wanted to de-escalate the situation, but very clearly escalating it on video. Now, who are you gonna believe? Gospel truth or your lying eyes? I mean, you can see what takes place in the video. You can see that the defendant is walking by the officer when he was grabbed. The officer could have said, officer safety. Carrying a firearm is not illegal in this country. Carrying a firearm is not illegal in this state. Not even if you're walking toward a police officer, especially after that officer or other officers told you to leave, to go somewhere else, to go get in his car, to go home after a long late shift. When you have actions that constitute violations of your rights, there's only one way to stop that, and that's to stand against those actions. And that's what your duty requires of you. This situation could have been handled in a lot of different ways. Now, you may not have liked the things that the defendant was saying to the officers. You may not like the way he was saying. But if you think back to voir dire, right? I asked all of you if arguing with an officer was resisting arrest. I mean, you hear him say, I'm getting into this vehicle voluntarily. Is that somebody who's resisting arrest? You saw him seized by multiple officers, grabbing and pulling and twisting and turning. Does that mean that he's resisting? No, I mean, the officer himself testified that all of the officers grabbed him at once to arrest him. At least he would admit that. He wasn't willing to admit that they all walked by the defendant several times without finding any reason, despite shining a light on him, to ask him anything. Well, that's because they were going after the people who were running. Well, that's not this defendant. It's not the defendant's fault that there was a disturbance that night. It's not the defendant's fault that officers had to respond to that disturbance. It's not the defendant's fault that those officers had to chase after people running away from them. You heard McLemore himself on the video say, go home or we're going to start PIing people. Now, as we discussed in testimony, PIing somebody or charging them with public intoxication does not require any evidence except for the officer's judgment. So when you hear an officer say, if y'all don't go home, I'm going to arrest you and charge you with this, they mean what they're saying. I don't know if McLemore had a bad day or not, but if he did, that's also not the defendant's fault. He issued a command. He wanted his command obeyed, whether it was right or wrong. Why? Because I said so. The only way to say that that type of behavior is unacceptable from those we entrust to carry firearms to use against whomever may be threatening the life of an officer or another to exercise the law, to do so faithfully to the law, cannot act in that manner. Firearms only seem to be illegal when you're in a lower socioeconomic aspect of the neighborhood. You're in a poor area, a high crime area, as the officer stated, right? Anytime else, go Second Amendment. We have our right to bear arms. God forbid you take a coworker home from work. Now, the defendant didn't have a firearm, but that's the excuse given to you for what took place, what you witnessed. I implore you, tell the state, tell Officer McLemore that it is not okay to behave that way, that he could have handled it differently, that this defendant did not resist arrest. Send a message clearly. Go in there, elect your foreman, have the foreman sign that top line on the verdict form, and be done with this. Thank you.
Okay. Mr. Hubel, you may proceed.
Good afternoon, everybody. First and foremost, I want to thank you all for your time and attention this week. It's very important, as defense counsel said, that you were all part of this justice process. Without y'all, it wouldn't function. I first wanted to discuss some of the points that the defendant brought up. The first thing that he brought up was that the officer wanted to de-escalate the situation. And from what you can see in the state's exhibits and testimony on the stand, that's undeniably true. The defendant was given multiple opportunities to leave the situation, and he opted not to. And you don't have to take my word for it. You can review the videos and see that yourself, that he could have easily left that situation. The defense could have handled, the defendant could have handled it differently that night as well, and we wouldn't be here today. Ben's also talked about the defendant not possessing a firearm, whether or not that's illegal. The officer never said that it was illegal to possess a firearm. In fact, said the opposite. It was just in that moment, it was concerned for the safety of the officers that were present. And defense in questioning yesterday was asking whether or not the defendant was heading towards the officers are away from them. If you review state's exhibits where Officer McLemore is, and the defendant's passing to the right, there are more officers in that direction as well. So he's not walking away from the officers, he's walking into a group of officers, potentially possessing a weapon. And responding to a disturbance in that, such as the name they were called out to, that's a very dangerous situation. In regards to the accusation that that the officer simply arrested this person because he wanted to, in regards to the public intoxication, the officer also testified that often in these cases where there are these loud, violent disturbances, as there was that night, many people involved in those are intoxicated. And he also testified that he saw signs of intoxication in the defendant, such as alcohol, he could smell alcohol in the breath, and saw his actual bloodshot. Defense also makes a call to action in regards to standing against what he perceives as injustice in this case. And to put it simply, one, like as I said earlier, the defendant handled the situation differently, we wouldn't be in court today. And two, if he felt that there's a perceived injustice going on, this is the proper venue to fight it in court, not in cops. Don't endanger yourself, don't endanger an officer or anyone in the surrounding areas. And with that aside, I want to take it back to what is actually central to this case, what controls this case, and that's the elements of the offense of resisting. And we'll go through them one by one. First, the identification of the defendant, Omar Young Senior. Both officers testified that that was the defendant. This individual, Omar Young Senior, was identified in court. You can see him on the videos in State's Exhibits 2 and 3. And defense during questioning also questioned as though the defendant was also within State's Exhibit number 1. So there's no doubt that this is the individual involved. There's no doubt he was there. On February 9th of 2025, this is also an issue where we see from officer testimony that it occurred on that date. You can see in the body camera footage that the date and time is listed in the top, I believe it's the top left corner. So there's no issue of fact in regards to the date on which it occurred, as well as the fact that it occurred in Jefferson County at the apartments at 3255 Elmira in Beaumont, Texas, in Jefferson County, Texas. That's officer testimony as well. Then there is no issue brought up in questioning to dispute that. These two, taken in tandem, did intentionally prevent or obstruct. And you can see the intent in the defendant from his demeanor throughout the encounter. From the very start, and including whenever he was detained for the pat down to make sure he didn't have a weapon. You can see that he pulls away from the officer, he tenses his body in an effort to resist that initial pat down. And he continues his resistance further whenever the officers attempt to place him under arrest. And it was to such an extent that other officers had to get involved. And he eventually had to be taken to the ground before being successfully taken into custody. And Joey McLemore, he testified to his own name on the stand. You heard his testimony. Holmes also identified him as an officer on the scene that night and identified him in the video on States too. And the fact that he was a person the defendant knew to be a police officer, there were marked units all over the apartments that night with red and blue lights on. Each of the officers on the scene, including Holmes and McLemore, were in uniform, so there's no real doubt as to whether the defendant knew that he was a peace officer. As we discussed earlier, from effecting an arrest of the defendant, Officer McLemore attempted to arrest the defendant. You can see that on the State's Exhibits 2 and 3 that the defendant resisted that effort and it required the help of other officers. And that use of force that's struggling against Officer McLemore was the pulling away that required multiple officers to assist him to the ground. And we talked about this specifically in voir dire. The use of force, different examples. Struggling against the officer by pulling away from him was generally agreed upon by the panel, if you'll recall, as a clear example of use of force by an individual. So, with that in mind, what I want to reiterate this time, having gone over the elements of the defendant in this case had multiple chances to make this not happen. We could have not been in court today if the defendant made better choices in these ways. If he had simply left whenever he was given multiple opportunities to leave. And this was after the defendant had already resisted that initial pat down and initial search, and after the officers had seen signs of intoxication that could have supported an arrest for public intoxication. But he was given an opportunity to leave. He chose not to. He made the decision to stick around. He made the decision to not comply with law enforcement. And ultimately, based on what he observed earlier, the signs of intoxication, he placed the defendant under arrest. for public intoxication. This is not an issue where the officers were arresting him simply because they're being recorded or anything like that. The officer Malcolm even provided his name to the defendant. Like, this is not a situation where they're trying to shield themselves or prevent people from seeing what's going on. There are people all around already videotaping them. So this is not a situation where the officer said something to hide. The officer in testimony was able to articulate facts that are sufficient to make the arrest for public intoxication. So this was a lawful arrest that the defendant resisted. So now comes the essentially the last part where I get to speak to you. And I just want to remind each and every one of you that you each have what your jury's duty is to decide the facts in the case, to follow the law provided in the charge, and to render a true verdict based on that in this case. And that consideration should be limited to the elements of the offense. In this case, those are ultimately what control the case. And you can look back at states, witnesses' testimony as well as the exhibits. Your foreperson will have to request that in writing, whoever that may be. If you're trying to get a specific the testimony, you have to be very clear about what snippet you want from that testimony. So make sure that that's clear and also signed by a foreperson, or if you want one of the exhibits, the video, you specifically, you can describe the video that you want to see and we can provide it to you. So again, thank you for your time and attention this week. I would ask that you go over the evidence carefully, follow the law provided in the charge, and render a true verdict of guilty in this case. Thank you all.
Okay, ladies and gentlemen, for the jury, at this time, the evidence, the court's charge, and the closing arguments of counsel are before you. I'm going to hand the verdict, the charge rather, to the bailiff together with the verdict form. They will be left with you in the jury room, and you will deliberate. Once all members of your jury are present and assembled in the jury room, the case is formally submitted to you, and you may begin your deliberation. So before you step down, I need to inform you that one person in the group is an alternate. Alternate is not allowed to go into the jury room. And the alternate in this case is Daniel A. Wilhelm. Is that okay? Okay, now Mr. Wilhelm, you'll have to stand by and be available and ready if one of the jurors is not able to finish the deliberation. So at this time, I'm going to hand this charge to the bailiff, and you can follow bailiff into the jury room. Hey, Mr. Wilhelm, you can either want to sit outside, and if you need any coffee or any water, we'll be happy to get it to you. Court is standing in recess until the jury reach a verdict.
Just in case.
Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 5 CCCR 0732, case of style of state of Texas versus Omar Young Senior. Let the record reflect that Mr. Young is present in court with his attorney, Marcus Wilkerson. Let the record also reflect that the state is present with Assistant Criminal District Attorneys, Attorney Andrew Hubel and Attorney Farrah Nixon. Let the record also reflect that the jury is not present in the courtroom. I have received a message from the jury that it has reached a verdict. Will a bailiff please bring the jury into the courtroom? Everyone, please stand. You may be seated. Let the record reflect that the attorney for the state, the attorney for the defendant, and all members of the jury are present in the courtroom, full person. Have you reached a verdict in this case? And is the verdict unanimous? That is, one that is agreed upon by all the jurors. Would you please hand the charge and the verdict form to the bailiff? Mr. Young, please stand. Full person is the verdict, the unanimous verdict of all members of the jury. Okay. We, the jury, find the defendant guilty as charged in the information with resisting arrest. Anyone would like to have the jury polled?
Yes, Your Honor.
Okay. Now, at this time, we're going to poll the jury. And that is, we're going to ask if it's your verdict. Okay, let's see this. Juror number 1 is Cindy Galicia. The court has reached a verdict. Is this your verdict? Randy, that's Rhodes? Okay. Ms. Rhodes, is this your verdict? Marvin Pascal, okay. Is this your verdict?
Yes.
Was that Tan Tran? And Ms. Tran, is this your verdict? Kurt Hallmark? Mr. Hallmark, is this your verdict?
Yes.
And Ashley Foster. Ms. Foster, is this your verdict?
Yes.
Okay. Okay, ladies and gentlemen of the jury, the defense previously had elected to have the jury set the punishment, then they have withdrawn the request for the jury
Yes,
to assess punishment.
yes, Your Honor.
Is that correct?
Yes,
And so at this time, the court is going to assess punishment in this case. Now, what the court normally does, the court normally reset the case for a a pre-sentence investigation report so that the court can be provided with the information that it needs to properly assess the punishment in this case. So at this time, we're going to reset the case to give the probation department an opportunity to prepare for the court a pre-sentence investigation report. Okay, so they need about 30 days.
We have something on April 30th. I'm just trying to 1:30, can we do May 1st at 9?
Well, we can do April 30th, that's fine.
What time?
Yeah, what time is that?
We can do it before jail one,
Okay,
April 30th before at 9 o'clock.
right,
Is that okay with you, Mr. Wilkerson?
As long as I'm not called to trial on CDC. Oh, but yeah, it should be fine.
April 30th?
okay, April 30th.
Yes.
Okay, this case will be reset for sentencing on April 30th at 9 a.m. And Mr. Young, you'll be given a notice of the court date, and then the probation department is going to be in contact with you regarding the pre-sentence investigation report. You would have to go over there.
You want him to report there today to get it.
Yes, get it
Yes.
started. Okay. Okay, so ladies and gentlemen of the jury, this will conclude your services in this trial. As I mentioned to you earlier, I'll be setting the punishment. First of all, I'd like to thank you for your time and attention that you have placed in this here particular case. Now, I know it was a difficult decision. Trials are difficult for individuals to make decisions. But I can assure you that the decision that you made, justice was done in this case, and we'd like to thank you for your time and attention. Now, you can return the badges that you have. You can put it on the countertop that's in front of you, in front of the jury box. And again, on behalf of the members of the staff here in County Court Outlaw Number 2, on behalf of the citizens of Jefferson County, we'd like to thank you for your time and attention. Now, as I mentioned to the members who were on the panel on Monday, anytime that you're in the area of County Court Outlaw Number 2, you can come and have a seat in your courtroom. Because as I told you, this courtroom is for the citizens of Jefferson County. I know that when you came to court on Monday, you looked over the top of the door, you say, this is County Court Outlaw Number 2, this is Judge Terrence Holmes Court. Well, I'm the presiding judge here, but this is your court. So anytime that you're in the area, you can have a seat in your courtroom. In fact, as I mentioned to the other jurors, you can have a seat in an area back there. We call it the peanut gallery, but you can't bring peanuts in here and eat because this is not the Texas Roadhouse. But you can come and see what goes on in County Court Outlaw Number 2. If you cannot make it, you can view the activities that go on in County Court Outlaw Number 2 on our YouTube channel. Now, your services is concluded. The bailiff is going to hand each and every one of you some letters. If you feel free, you could drop us a line. And before you leave, I usually give everyone a handshake. But as I mentioned to folks earlier, we still have COVID in our community. So I can't give you a physical handshake, but I can give you what I call an air handshake. So thank you for being here today. And thank you for participating in this trial. Now, the lawyers may want to talk to you. You can talk to them if you want to. If you don't want to, you don't have to talk to them. Okay? So at this time, you're excused, and each and every one of you have a blessed day. Court will be in recess.
And I'm sorry I couldn't talk to you the other day. It was just not allowed.
And this will conclude the trial in County Court at Law number 2,
I'll be right back.
Jefferson County, Texas, Judge Terrence Holmes presiding. Everyone, please have a blessed day.
Thank you.
Thank you, Your Honor.